Peace, Oakland. This is your host, Seneca Scott. We're back with an extremely urgent and important episode today that had to do with the future of Oakland's finances. As you know, we've been the only media outlet covering the bankruptcy case from International Terminal Solutions and the city of Oakland, where they're suing us for $1 billion related to the coal lawsuit. Now, we've been covering this through multiple episodes. You're going to have to go back and watch a few of them if you want to get the full scope. So I'll break it down with a quick introduction. But first, I need to bring on a very special guest who's going to help us navigate this legal case. I have with us none other than retired Judge Brenda Harbin-Forte. She is the leader of the Oakland recall, former mayor and recently indicted Chantal. She continues to be a fierce advocate, served as the general counsel for the NAACP 27 years before she retired a few years ago as the Alameda County Superior Court judge, serving across pretty much every sector that a judge can do. She has mentored many judges. She's won all sorts of awards. I've probably given this introduction before, but in case you don't know who the judge is, you need to know her pedigree and why it's so important and valuable that we have her sage wisdom to help us navigate this lawsuit. With no further ado, Judge Brenda Harbin-Forte. I'm very excited to have you back. So we're talking about this coal lawsuit, and I wanted to have you here to go back and forth. I wish we had a big enough studio we could sit in the same room. But we're building that. We're going to have that soon. But this is crazy. Now, we're getting sued for $1 billion. And usually when you throw words around like that, people say, oh, that's never going to happen. But for those of you who are watching, I'm going to give you a very, very consolidated breakdown. 9 years ago, California Partner Group, which is Phil Tagami and Mark McClure, formed a company in order to ship bulk coal from Utah to the port of Oakland. Then Mayor Libby Schaaf signed this agreement and gave them a lease at the port of Oakland, and they were ready to go ahead and do their thing. Then the Sierra Club and a group called No Coal in Oakland formed and basically went to war to stop this deal. Now, we've talked about this before. I'm not an advocate for shipping coal, especially uncovered coal that has dust particles going through a neighborhood that I live in a neighborhood that has seen an unfair share of environmental racism or classism, however you want to put it, because poor people always seem to end up in these toxic waste dumps and all of that. And so when I ran for City Council District 3 in 2020, I signed the pledge. I didn't think twice about it the way that it was presented to me, that they want to ship dirty coal through Oakland. Why are you doing it? But then I actually learned more when I ran for mayor. The city of Oakland signed that deal. They went back on that deal. They've lost several lawsuits that's been going through court for 9 years now. We spent tens of millions of dollars of Oakland taxpayer money on these lawsuits that are losing lawsuits because the lease was a valid lease, and we signed the deal. There were several options for no coal leases. There were options to ship the coal covered. Every single very common sense solution presented by California Partner Group has been shot down because of spite. And now this is where ideology comes in. The No Coal in Oakland and the Sierra Club have an ideological stance against fossil fuel. And so they are in a war against the fossil fuel industry. Regardless of what you think about that, that's their war, not the city of Oakland. And so they've hijacked our city attorney's department, made every elected official sign a pledge that they wouldn't speak against coal, and used that in order to fund a multi-year, tens of millions of dollar lawsuit, now spanning multiple states, that we lost. And we lost the lawsuit. Then another company, International Terminal Solutions, ITS, that was formed and then lobbied and represented by Greg McConnell, lobbyist, Oakland legend, and one of the top lobbyists in the last decade in our market. And he worked exclusively for them. He's got several, again, you can watch Gotham Oakland episodes. We got it all laid out. And Mr. McConnell was lobbying for this group, and they went bankrupt. And this is a company that was worth over $1 billion. They formed this company. The valuation for the company was over $1 billion. Now they formed this company for the sole purpose. They're a single entity company, meaning that the sole purpose for them to be in business was to ship the coal from Utah to California. And because of this deal going south, they lost everything. And they took a lot of money and they went bankrupt. And in the bankruptcy case, the city of Oakland hired out-of-state lawyers and sent city attorneys to Kentucky to protest International Terminal Solutions bankruptcy case that had absolutely nothing to do with the city of Oakland. This was a company that went bankrupt because of our lease, and we should have just stayed out of it. But we didn't stay out of it. We actually presented a 28-page brief that the judge that we're going to be talking about today tore to shreds, but used it to say that we injected ourselves into their bankruptcy case. And as a result of us in that 28-page brief claiming that they had no valid lease, International Terminal Solution barely got any money. They were valued at over $1 billion because Oakland injected itself and basically lied to the judge and said that they never had a valid lease in the first place. The judge was like, why are you forming a single entity company without a valid lease? And then you want us to give you money in bankruptcy? No, we're going to give you a few tens of millions of dollars. And I believe that they got less than $50 million for a company that was valued at over $1 billion at the time they were in the bankruptcy. Now, the moment Oakland lost this lawsuit last year in the summertime, I forgot the exact month, the judge and the judge in the lawsuit for California Partner Group, there are two lawsuits going on here. There's the coal lawsuit with California Partner Group that they won, and that's the current lawsuit, that's the bankruptcy case for International Terminal Solutions. As a result, the lawsuit for the coal lawsuit, the judge said it's over, the lease is valid. We're not discussing this lease anymore. That lease is deemed valid. I don't care what, how many challenges, it's valid. Because there's other cases going on that are depending on this legal opinion. So once the ITS got that ruling that that lease was valid, it gave them very strong standing to bring a case against Oakland for lying to the bankruptcy judge, which resulted in them getting a lot less than they should have got. So now we're getting sued for $1 billion. And last summer, I believe, the judge ordered for the city of Oakland to do what's called a Rule 2004 examination. What that meant is that the city of Oakland had to turn over all of its finances, and the Sierra Club, who's also being sued in the very same lawsuit, had to turn over their finances related to the stadium deal. Now, how did the Coliseum deal all of a sudden become the central focus of the financial breakdown of this bankruptcy case? I'll tell you why. Oakland's broke. One of our most valuable assets is the stadium. And the fact that we were selling it without disclosure and appraisal, selling a revenue-producing asset, like a thief in the night, this company thinks that we're trying to hide assets so they can't take it in bankruptcy. What this means is that there's a potential for Oakland to lose the Coliseum or have to be forced to sell it at a reasonable rate to pay for this multi-$100 million up to $1 billion judgment. The judge has ruled against Oakland at every turn, which takes us to today. And if we lose this lawsuit, which I think we will, we're going to owe them anywhere between $1 and $1 billion. So you could probably be around a few $100 million at least. Oakland can't even afford a few $1 million at this point. To get $100+ million judgment against us or not be able to sell the stadium as planned will absolutely send Oakland into bankruptcy, which means no coal in Oakland, Ryan Richardson, Barbara Parker, Oakland City Attorney's Office, everyone who signed that pledge, who's been elected to office, and all of us who've been sleepwalking at the wheel because you didn't vote for Judge Brenda, who would have stopped this crap for city attorney. Anyway, that brings us to today's episode. We are going to go through how this co-bankruptcy case threatens to bankrupt the city, the first thing I'm going to show you is the actual order granting to compel the city of Oakland to comply with the Rule 2004 examination. I think I can handle this without Judge Brenda's help before we get to the hard stuff. And then she's going to be doing a lot of talking and not me. But in the matter coming before the court on the motion to compel, basically the judge had to compel the city, who was not complying with the original order, to comply with the court order granting Rule 2004 motion, filed by Insight Terminal, not International, Insight Terminal Solutions. I've been saying International the whole episode. My bad. And the court, having reviewed and considered the motion to compel being otherwise sufficiently advised, it is ordered that the motion to compel is granted, and the city of Oakland must comply with this memorandum and give the documents responsive to the discovery request on or before March 14, 2025. What is today's, Judge Brenda?
What is today's date? This is the 14th of today? My
Oh,
goodness.
that means by close
12.
of business today.
Oh, my goodness.
In 4 hours and 10 minutes. They better turn this stuff, or maybe is it by close of business? Is it today? They have to
Typically
midnight.
by close of business.
Well, let's give them to midnight.
Yes.
Or there are going to be some bad things coming our way. So we're going to get into the transcript because this is fascinating. I want to go through, and what we're going to be showing you, and I want the judge to give her an opinion on a few things. This is the actual transcript of what was being said in court. It is shocking, in my opinion, what's going on here. And so the first page we're going to go to, Judge Brenda, you have some notes. It's page 27, right?
Sure, right. And Seneca, let's give a little bit more background in terms of what documents are being sought. They've been trying to get documents on the Coliseum sale. And that is what everybody knows, that there are documents, there are contracts, there are all kinds of negotiations, there are all kinds of documents related to the sale of the Coliseum. But you would know that if you were to listen to the city's attorney in this case. They're basically saying that we don't have any documents. We don't have anything in our possession. But
so
anyway.
Oakland's attorney is claiming that there's 0 documents, just so everyone can follow along here, because we skipped the first 27 pages.
Yeah.
The other ITS attorney saying Oakland's claiming there are no documents related to the sale.
Right. And no documents that are responsive to the court's order to produce documents related to the sale. So they're saying that they don't have, they've said some inconsistent things, but it's kind of like, well, we don't have any documents that would respond to the demand to produce documents related to the sale. So,
So that picks up here on page 26, line 19.
Mm-hmm.
We're going to provide links to all of this so everyone can read these yourself. So on page 26, line 19, I'm going to read it in my acting voice. And then Judge Brenda will interpret this. And for us normal people, what is the court? And when they say the court, that's the judge talking. Is that correct?
Correct.
Okay. So the judge says here, what's the judge's name in this case?
This is Lord, Judge Lord.
Lord, Lord.
Correct. Hold on 1 second. Let me get the.
Ooh, that's scary. I don't want anybody named Judge Lord ruling against Oakland. It's like the Lord is about to strike us down for lying about the coal deal.
Wait a second now. Now, of course, I can't find anything with a name on it and stuff, but I believe it's Judge Lord. Yeah.
I can real quick. I can tell you it is Judge Joanne Lloyd, Lloyd.
Lloyd. Okay.
Lloyd. So Judge Lloyd says, well, what's happening here? This has gotten to, you filed a motion to compel because you think on the 2004 order that they're playing a very narrow construction of the court order, and that then the original order and the motion to reconsider. You haven't filed a motion for a protective order or to limit or anything, and so now we're into semantics. This is semantics. If you choose, if the city City of Oakland, chooses to narrow its view of what has been raised in the court's memoranda opinion, the first one, and then the motion to reconsider, and it turns out that there are documents that are responsive to the court's original determination, then there will be a motion for sanctions that will follow. And if it is discovered that the city of Oakland has narrowly reviewed this court's order and courts can't look into your files or anything, the only way the court gets to react to any of this is that if it is discovered that there is not forthright and full response to discovery. There is not a time to discover legit or to argue legitimacy of this discovery. It is not a time to discover the admissibility of this discovery or its relevance or any. It's just it only has to be superficially related and within the way the Sixth Circuit Court of Appeals interprets its bankruptcy rule 2004 order in accordance with my opinion. But where we're going with this, whether you filed a motion to compel or not, is a motion for sanction. If ITS sincerely believes that there has been a breach of the appropriate reading of the court's order and the Sixth Circuit's rule. Now, what you're saying is if the court enters the order compelling, it's like the court has already decided there's a default. Basically, I'm not going to get into the rest, but what does this mean? What is the judge saying here? And the tone of it, how do you interpret this, Judge Brenda?
Well, the judge is very clearly getting, I won't say exasperated because, we judges don't get exasperated, but the judge is really, I think the judge can see through the roadblocks that the city is trying to put up in terms of saying that there are no responsive documents. And the judge is clearly sending the message that listen, you haven't tried to file a motion for a protective order. And a motion for a protective order means that, Judge, there are some documents out there and everything, but for one reason or another, we shouldn't have to produce those documents. They're privileged, they're something, whatever. And so we shouldn't have to show them to the other side. But in general, in any lawsuit, you are required to produce responsive documents if you have them. And you don't argue right now that, Judge, you should not have ordered us to produce those documents. You go in on an order and you say, hey, Judge, please don't make us have to produce those documents. That's a protective order. And the judge is pointing out, you didn't come in on a protective order. You haven't done anything, or you haven't
For
said,
sure.
limit the production to these documents or this category of documents. You haven't done any of those things. You're basically just saying, I'm not going to produce the documents that you've ordered. And he's clearly sending the message. She's clearly sending the message, rather, that I'm not going to have this. This could lead to sanctions against the city.
And what are sanctions? When they say sanctions, what are the scope of a type of sanctions that could happen in a bankruptcy case like this?
Well, typically it would be some monetary sanctions. That is the most common way. But in the worst case scenario, there could be what we call evidence preclusion sanctions, which means that you don't even get an opportunity to put on a defense. I'm not going to let you put on a defense to these allegations because you have not performed your duties of providing the other side with appropriate documents. So it could
No,
be devastating.
this is just discovery.
This is discovery, and discovery means we need to see what the other side has. And in the
Why the
worst case
focus on
scenario, yeah, in a worst case scenario, the judge can say, I'm going to strike your answer. I'm going to enter a default judgment against you and let the other side prove up damages. That's the
a
worst
default
case scenario.
judgment in a bankruptcy case, period?
I'm sorry?
You mean a default judgment in the bankruptcy case?
Essentially, yes. That says you don't get a chance to put on a defense.
Wow. So there's no jury here. The judge takes into
Correct.
account the evidence and make their own decision.
Correct, correct. Now
And
that's a
that
worst
means
case scenario, though. That's when it's really bad. Typically, more common is a monetary sanction. So the judge then says, "All right, fine." Sanctions, monetary sanctions equaling essentially a fine. So the judge could say, "You know what? The other side has had to spend $20,000 trying to get you into court and everything, $50,000 or whatever. They've done all this, and so I'm going to make you pay the other side that kind of money."
Wow. Okay. And could it be a daily sanctions until they turn it in? Could there be any type of?
Sometimes, yeah, again, depending on how egregious it is.
But the most
So
severe
the
would be that
judge
the
has
judge
wide
says
latitude. That's why the judge, I think this judge is being very careful. She's being very careful. She's making a very good record. And she's basically saying, I know what you're doing, and okay, you're an advocate, you're a litigator and everything. I'm not going to punish you for that. But listen, here's the deal.
it's over. That it's
You
over.
got to do what you need to do.
Okay. So we're going to bring up page 33, which goes into
Page,
and to bring that up.
what page are
Um,
we?
page 33,
Okay.
line 8.
Right.
And this is ITS's lawyer.
Mm-hmm.
Typically, I want to just talk about what the judge is saying, but I think this
Mm-hmm.
is valuable since the judge is pretty much accepting ITS's argument
Mm-hmm.
and approving it,
Mm-hmm.
and their motion to compel it was granted. I think there's some value in reading it. So
Yes.
this is the judge, the lawyer from ITS. I don't know the name. I'm not gonna go. I'm not gonna ask you. It's fine. So I'm all. I don't know. Oh crap! You dropped off again. Okay, yeah. I don't know how we can handle this impasse and get past it. But if the city's position is that there are
Okay.
no documents at all related to the Coliseum, I can see you, Judge Brenda. I can see you.
Seneca.
I can see you. Oh,
Okay.
it's okay. We're in Mercury is in microwaves right now. Um,
Okay.
Everybody's technology screwed up. I got bank transfers not working and my phone blowing up with
Oh
everything.
no.
The world is ending, but I'm ignoring all those calls to
Oh
focus on this very
no.
important interview. So I'm gonna just go back. Just in case you missed it, ITS's lawyer is talking about why they're frustrated at the impasse and why they filed a motion to compel. Now, keep
Correct.
in mind, they're this bankruptcy case is trying to find out the city's finances and the city's potential financial ability to pay if indeed a bankruptcy case is granted.
Correct.
And it's all this emphasis on the stadium. Just remember that. We're not talking about nothing else but this stadium. And isn't it odd that they're trying to offload this stadium quickly and such? I mean, I've said that before, but I want you to follow me here. So I don't know how we can handle this impasse and get past it, but if the city's position is that there are no documents at all related to the Coliseum transaction that's been going on for over a year, no LOI, that's a letter of intent, no term sheet, no contract, nothing, no communication related to these types of documents. I'm not saying that there is, but as an example, then by definition, I believe if the city is preparing to finalize that deal, it's a fraudulent transfer, right? There's no document, so it must be fraud. I don't believe that's the case, but I'm saying that's how silly it is. There must be document. I just don't know how we impose upon the city to act in good faith and just give us the document and we are impact judge because I don't know what else we can do. Now, there is an LOI. We've shared it on Gotham Oakland. There's been multiple term sheets because they've changed the deal multiple times. We've shared every term sheet on Gotham Oakland. This is public information, but the lawyer, I guess, is like, I'm not going through all of that work. You have to turn it over. We've won the Rule 2004 examination, um, and etc. So I'm going to also go through I know I say this, the city has in good faith tried to comply with the, oh, this is the other lawyer saying that they tried to comply in good faith. So what do you take from this lawyer's frustration and what's your interpretation of ITS's statement here?
Well, they're telling the judge what the judge already knows and certainly suspects, but is trying to give the city an opportunity to do the right thing. Which is that, they're saying they don't have any documents, Your Honor. That, they're about to finalize the sale, but they don't have anything to give us related to the sale.
Why,
And,
in your opinion, why do you think the city is withholding these documents?
it's very troubling. I think that there could be an argument that they are trying to perpetrate a fraud. And let me tell you what a fraudulent transfer is. That is when you are trying to transfer some assets to keep a creditor from getting those documents, those
So like a
assets,
divorce, trying to hide money and assets in a
trying to
divorce.
hide money and everything. And so you see it all, and no, and that transfer, that transaction can be set
Hmm.
aside if it is fraudulent. If you did it for the purpose of trying to hide your assets from from a creditor. So so that's why you'll hear the discussion about fraud, because it can be voided. That transaction can be completely voided, and there could be the transaction and the assets, money, whatever, can be clawed back and can be returned to who it would be the creditor. Um, so um, so it's a big deal, and I think the attorney is saying, they're saying there's nothing, as again, no letter of intent, no term sheet, no contract. And who in Oakland or anywhere does not know that the Coliseum sale has been going on? There have been discussions, and there have been
Where's the
discussions.
money, Ray? Where is the money,
Where
Ray?
is the money exactly?
Come
And that there
on.
have been discussions about when the payments were due and everything. And
Oh
so the
yeah.
city's attorney is like, well, we don't have, and what they're playing games. And when the judge mentions semantics as well, they're playing games. Is all they're doing, and they're trying
That
to
is
read the
most of the
judge's order
transcript.
very narrowly, and the
Yeah,
judge is not having it.
not having it. And I'm not, the reason we picked out some good points to share with you because it's a 40 something page document. And if you read it, you will see the city of Oakland lawyers absolutely playing games. Next one to look at page 35. And this is at the very top, line one, and I'll read it. Judge Lloyd. Well, I'm going to enforce my order that, I mean, you can, I'm glad your client is on. The city is going to enforce this order. The court
The
is going
court.
to enforce this order. The city's interpretation of that, I mean, they can read it however they want. It's a curiosity of sitting in this position and entering orders and finding out later that other people don't read the same thing. Like they don't, when you're in a negotiation, a lot of times people don't even read the same thing. But I know what my jurisdiction is. Another court might disagree with me, and other people might disagree with me. But I'm not letting off the horse that I'm riding. This is the horse is riding, because many, many years, decades and decades have proven to me that this is what needs to be done. And so I hear you, Miss Winberg. I've heard you, and I absolutely understand you. I remember that the whole group from the city of Oakland came, and I listened to everything they said, and I still rode the horse that I understand. And I've reviewed the law. And the city of Oakland may disagree, probably does. I mean, they clearly do disagree. But this is within the scope of this court's jurisdiction, what is in this order, and I'm going to enforce that order. I will sign the order tendered today. And if it turns out that the city has fully complied with the full spirit of the order that the court has entered, and it's been wrestling with this for quite some time. If it turns out that the city is fully in good faith, complied with the review to that, then it goes away. If it is determined that at some point in the future that it has not, I would feel sure that the court would then have to consider its motion for sanction, because all motions to compel is that there hasn't been a good faith cooperation. It is opinion. It is an opinion. But now today, I believe that there is enough of a disconnect with how the city reads this and how the court intends in that the motion, the order on compelling is warranted. Whether or not it will lead to sanctions in the future is anyone's guess. What is your interpretation of the judge's statement there that I just read?
I think it's very clear again that the judge is trying to give the city of Oakland an off ramp and basically saying, okay, I could sanction you, and if I find out that you haven't acted in good faith, I can sanction you. But okay, for right now, I'm going to say that perhaps you misread the order. Perhaps you didn't think it was as broad as as I intended, and perhaps then that is a reason that you didn't comply with the order and turn over the documents that you know exist. One of the other things that was interesting is that the city's attorney at some point, and this is an outside law firm, by the way, the city's attorney at one point was saying, these are documents that could be obtained through a records
FOI.
request, a public records request. And it's kind of like, and the judge and the attorney were like, well, if you're saying that it could be obtained through a public records
Turn
request,
him
then
over.
it must mean that there are some documents there that would be available through a public records request. Why are you saying that there are no responsive documents?
Give
So
the documents to the courts.
again, give them to the other side. They're
Yeah.
entitled to those documents.
Then
And
yeah.
so I think the judge, and that's why I say the judge is making a very good record, and is saying, I'm giving you every option. I'm going to sign this order as well, and I expect your compliance with it immediately because they have been waiting months to get these
Months. And the
documents.
deadline is today. And the fiscal
Yeah,
year
and
looms. So
everybody knows that everybody knows that there are documents related to the sale of the Coliseum. It's been in all the press.
yeah,
So
it's ridiculous. I would mention this for those of you who may not understand. Not only is bankruptcy case an urgent proceeding, all courts deserve to be done in a timely manner, but that's not the
right.
reality sometimes. But especially when it comes to the proximity to the end of the fiscal year, ending in June, which most businesses choose. Like there's business to be done, and so they're trying to come to a decision. And like I've said before many times, if this doesn't go our way, whoever gets elected mayor of Oakland is going to have to deal with this. City
Yeah.
council has been briefed on this several times, but there's been no sense of
Yep.
urgency to stop the city. I don't know if they can stop it at this point. We've messed up. There's no out. Like, how there's the scene in the movie, if you've ever seen A Bronx Tale, and
So,
the bikers are in the bar, and he asked them to leave all nice, and then they didn't leave, and he poured a beer on them, and he just went and locked the door. Remember what he said? He said,
I
now
can
you can't
remember.
leave.
Now you
He says,
can't
now you
leave.
can't
Wow.
leave. So
Wow.
the door's been closed. Now Oakland can't leave. We can't get
Yes.
out of this
Yes.
$1 billion lawsuit. We're in some serious trouble. All right, next slide, and then we'll move on to the last part, and then we'll wrap up the interview. We're going to talk about no coal in Oakland. Do they own City Hall? Because it looks like they do. All right, so this is page 39, and this part I get a kick out of. I'm going to read it. Judge Lloyd. Now, I should be doing a woman's voice, but I don't do the very good woman's voice. So I'm going to pretend Judge Lloyd is a man, but it's not. It's a
No,
lady.
yeah.
So I'll tell you with the city of Oakland, it's like the Sierra Club who's not up today. Jerry is gone. But everybody got a crack at this a couple of times. Let me interpret that for those of you who don't know what's going on. As I said before, the Sierra Club is also being sued for $1 billion. It's the exact same Rule 2004 examination of their finances. And the judge also wants to see a correspondence audit of all communications between the city of Oakland and the Sierra Club. Draw your own conclusions about what's going on there. It is what it is now. The court is not going to revisit the terminology of its order or the spirit, and therefore I'm going to sign the order tendered by ITS. And if it turns out, and by the way, as of today, I am still the judge on the case. Nobody has removed. The reference hasn't been withdrawn. There's been no stay of this. It is, I'm tagged. I'm it. And that being the case, the court understands what the order of compelling means. The word compelling doesn't mean bad behavior. It means it is time to read the order an expansion of what you have discussed today. And if you disagree with that, you're always entitled to disagree. Then there are remedies for your disagreement with the court's order. But the court is not going to provide any more elucidation to the city of Oakland beyond what is there and based upon the court's order on the compelling. Full and good faith, full response. Okay? You made excellent arguments, but these are the worst things you can do as a sitting judge. It's dealing with a discovery because the court doesn't actually know what you're talking about in terms of the tactile experience of looking through a file or understanding a database or talking to a client. The court has to see these things in a very abstract way. And the best thing the court can do is to move the parties along in the most appropriate way using the bankruptcy code and the federal rules of civil procedure, United States bankruptcy procedure, and any of these rules. And this is the discovery event action, even when you're talking about the 2004, it is broadly interpreted in accordance with the court's prior opinion. I'm sure the city of Oakland disagrees on that, of course, because they're a litigant. Litigants are always going to disagree with the trial judge eventually at some point, and the court has to call balls, strikes, walks, or whatever it is. I never played baseball, of course. That's it. I'm going to sign the order. Miss Weinberg, you did a fine job, but I'm telling you that's it. I'm going to call it to a conclusion, and you are going to have to run out of here and get to work and take your best hold if you cannot resolve this. Meaning it's due today, get to work. All right, how do you interpret what seems to me to be a very strong and stern scolding by the judge, as nicely as you said as possible to give them an out? What do you interpret for this before we move on to the next section?
That the judge is done with the gamesmanship. And I will not allow you to continue to try to weasel out of your obligations.
Bless you.
Excuse me. Excuse me. Sorry. Yeah,
So they
that's
don't
very,
think
very
people acting
clear.
in bad faith. They keep saying good faith, but they're really saying without saying is you guys are acting in bad faith. Would that be safe
Mhm.
to say?
I think the judge is saying, I'm not yet ready to find that you're acting in bad faith. There is a suggestion that you are, and I might make that finding later on. So I'm going to give you an opportunity to avoid that finding. So go and do what I've ordered you to do. We're not
So maybe you
revisiting the
just
order.
farted. Maybe you don't stink. Maybe you don't have bad BO. You just farted today.
Right, right.
Okay.
But maybe you know what I'm saying. You can try to reread the order. We revisit. That's why it says I'm not getting off the horse I'm riding in on. I'm staying on this horse. I'm not going to change the order. You know what you're supposed to do, and stop playing games. I'm just actually kind of shocked that the city is allowing its attorney to continue to do. It's been months since that order was issued, and I'm just shocked that they have not given over the documents, or that they would step into court basically and misrepresent to the court the existence of responsive documents.
I agree. It is. I'm not shocked because I've seen enough incompetence from the city attorney's office, which is one of the reasons I was so excited to have the potential to have someone like you in that office and clean it up.
Mhm.
Alas, that did not happen. But
Mhm.
I'm not shocked. Unfortunately, it's part for course for
Mhm.
the combination of incompetence and greed that has been exhibited from the city of Oakland's elected officials and our staff.
Yes.
Quite sadly,
Yeah.
bringing us to our next section. There's no coal in Oakland owns. Hold on, let me hide that. Y'all didn't see that. Let me see that. Own. It's funny because I always say I'm gonna edit it out, but I never do. There's no coal in Oakland owns City Hall. All right, so we're gonna share a little document Judge Brenda sent me. No coal in Oakland's website and which city council members have signed it. The majority of candidates. So I would say this: every single elected official, with the exceptions of Michael Houston, city auditor, because they probably just never got to him. Oh no, what happened? I lost Judge Brenda. All right, we are back rolling. We just took a little bathroom break because we've been here for 40 minutes. But we're deep diving today. This is why we
Mhm.
have the show so people can actually learn a thing or two. So while you were gone, I queued up a few things. First is, you know, this is deeper than you know. This is very, very. I'm going to show you just the extent of this. After everything you heard, right? I want you to understand just how much these people are playing with fire. So this is the no color Oakland people. They made everyone sign Every single person besides Ken Houston, I think Michael Houston from City Auditor, because they probably just forgot about him because people forget about that office. And maybe he did sign. I'm not sure. I don't see his name. But again, I signed when I was running for City Council District 3 in 2020. I did not sign. And when I ran for mayor in 2022. Um, Judge Brenda did not sign because as city attorney, she can't say I'm never going to fight these people. It's not about that. She has to do what's best for the city of Oakland and uphold contracts that previous administrations have signed and protect the city from being bankrupted by $1 billion lawsuit. I think maybe a city attorney would care more about that than doing the work of the Sierra Club. But I also want to share and present this. Judge Brenda, check this out. John Brooks owns ITS. This is March 5th, this letter. That's not even 2 weeks ago. They wrote a letter to him to keep coal out of Oakland. Right? Talk about he has no root. They're trying to be all nice. Talking about you have Parkinson, coal is bad, and all of this stuff. But here's what I want to get at. Here's all the organizations sponsoring it. Look at this, y'all. Look at all these people. All of this work and intention while Oakland's covered in graffiti, budget bankrupt, public safety suffering. But when it comes to performative altruism, there's no limit of support. Wellstone, Berkeley, but I don't see Barbara Lee. I don't see Barbara Lee. This is in alphabetical order. Let's see if Barbara Lee's here. FGLIJKLMNOP. We're almost. All right, we're at the Lee. You see Barbara Lee?
No.
Barbara Lee ain't on the sign.
That must mean she wants to have coal in Oakland.
That must mean, I can tell you this for fact. Barbara Lee talks to the coal people. Not gonna name no names. Because Barbara Lee, like any responsible leader, meets with everyone who's a stakeholder. And someone who holds the financial future of Oakland in jeopardy is a stakeholder. Also, California Partner Groups has offered solutions to allow Oakland to not have to pay the money that they owe, but just take it out of the lease. Had they accepted this deal a few months ago, we would already have started making money off of that lease. So they've offered, just like the bankruptcy court judge, everyone's done everything they could to bend over backwards because, to their credit, they've organized damn near the whole world against coal. But the fact remains, it doesn't matter in court. We signed that deal. Libby Schaff signed it. So I'm going to end the show with this part. Why are they doing this? What are your thoughts about Barbara Lee not being on this pledge? They used this to drag your name through the mud. And before I turn it over, because I'm not going to say much for the rest of this episode, they always talk about being misogynistic, talking bad about black women, attacking black women, all these things the progressives say when it's someone they agree with. Well, when it took a 27-year judge who just disappeared to camera again, so hopefully to come back, I'm going to pause it. So, Judge Brenda, why are they doing this? I wanted to talk about the pledge. I was just saying before, it looks like these people the character assassination that they did for you for not signing this pledge. I can't hear you, by the way.
Oh, you can't?
I can hear you. Never mind. That's my audio.
Okay.
The character assassination. I'm watching dubs on TV, and all of a sudden I see Judge Brenda wants dirty coal shipped through Oakland.
Right.
All because you refused to sign this pledge because of what we're talking about today. It's the bad case. We lost the case.
Yes, absolutely. And it was unethical for anyone to sign it, quite frankly. And here is the candidates for city attorney, the ones who are sitting now. signed a pledge that says, as a candidate for Oakland City Council, I hereby express my strong opposition to allowing the storage or handling of coal or petroleum coke in Oakland, including specifically at a West Gateway terminal. If elected, I will direct the city attorney to continue to pursue an enforceable coal and petroleum coke prohibition without loopholes, binding on the current West Gateway lessees, their sub-lessees, and any successors in interest. In the event the city attorney is unable to achieve such a prohibition, whether through settlement or court judgment, I will support the city's pursuit of every feasible regulatory, legislative, and legal strategy to prevent the handling of coal or petroleum coke. And Rowena Brown, Carol Fife, Zach Unger, and Noel Gallo, the current city council members who ran last year, signed that pledge. Ken Houston, the only one who was elected to D7 last year, refused to sign. I am assuming that in the past, the following council members signed: Rebecca Kaplan, who's now D2
Oh
interim,
yeah. Oh
Janani
yeah.
Ramachandran, Kevin Jenkins, who was elected to D6 and current interim mayor. Now, I'm assuming that they signed that in the past. Shane Tao signed that. And here's what they have done. They've abdicated their responsibilities to look out for what's in the best interest of Oakland, particularly fiscally and financially. And they have refused to accept the fact that even the bankruptcy judge found last year in November, you've lost every lawsuit that you filed. You've lost every one of them, and we have told you that the lease is legal, it's appropriate, and it is enforceable. So when I was running for city attorney, it was okay. I don't want coal in Oakland. And if we were starting out initially where we had a choice and a voice in the matter, we would not have agreed to it. But that train left the station a long time ago. And we do not have the money to continue to assert these meritless positions. Let's get to the bargaining table. Let's see what we can work out. Let's see how we can settle this case to mitigate and ameliorate the damages. But we cannot afford to continue to fight. We lose every time, and millions of dollars have been spent. We talk about homelessness in Oakland, trying to house and trying to provide services, trying to provide more public protection. And what you have are city council people and the city attorney's office abdicating their responsibility to the general public and allowing the no call in Oakland people to treat the city attorney's office as their own personal law firm to pursue a litigation, to pursue a strategy that is not in the best interest of Oakland. It's my tax money that is going to pay all these outside firms. And they're fine, they're making money so they can go into the bankruptcy court judge and try to pretend that, oh, I don't really understand what it means when you ask for documents relating to the sale of the Coliseum. You can play those kinds of games on somebody else's dime, and
Yeah.
they are
But
doing
we're
that, and
closing
they are
fire
sending
station.
they're
We're
sending the
closing.
city
Yeah.
to bankruptcy. And it doesn't make any sense for them to do that. And if I'm spending somebody else's money, I can take that position. But I think that particularly for the members of the city council now, they need to understand that we did not elect them to become for the city attorney's office to be the personal law firm for everybody who has a gripe. And so, yes, if we were in the beginning, but I would never have voted for coal in Oakland initially. I was looking at it from a perspective of, here we are. This is what we are. And this is what we have to live with. And they've tried everything. They tried an ordinance. The city tried an ordinance to try to undo the agreement, and the courts laughed them out of court. They've tried every angle. And in fact, there was at some point a settlement, a no coal settlement.
Yep.
And
And
then
they
the no
turned it
coal and
down.
Oakland people
They
said it
turned it
wasn't
down
good
because they
enough.
wanted to punish them.
They wanted to punish them. They said it wasn't good enough. So the amount of money that is going toward this, and the city attorney's office does not disclose how
Nine
much
years.
money, how many millions of dollars they have already
Ten
spent on this case.
tens of millions. I filed a public records request. They're legally out of compliance by many, many days and months.
Uh-huh.
I will follow up on that. But it's tens of millions of dollars that have been spent, not only on outside lawyers, but also if you have to account for the time that our own attorneys are spending on this
Right,
case,
right,
the travel time, the travel
right,
expenses.
right.
We did not have to go stop someone's bankruptcy case. That had nothing to
Yes,
do with stopping Cole in Oakland. They wanted to
right.
bury that company, and now we can't leave. So
Yes.
there's no way out of this. ITS fully intends to make us pay dearly for what we did, and
Yeah.
I'm very concerned about our financial future. And I think that when it finally comes out, that connection between the stadium deal, the no call in
Yes.
Oakland, the criminal cabal that has been running our city into the ground and
Right.
hijacking our city attorney's office, hijacking our school board. We've had a city taken over by,
Yeah.
and I always put air quotes on progressive, because with someone like yourself at a 27-year legacy of being a progressive judge, I don't want to disrespect what your progress
Exactly.
was. Like, you make
Exactly.
progress. You help more Black people into
Mm-hmm.
like, you can document the progress that you're proud of in your legacy.
Of
And to me,
course.
that's what being a progressive used to be about.
Yes.
Being self-determined, cooperative economics, like moving our people forward. And
Mhm.
frankly, we've been co-opted by people who have used our victimhood,
Yeah.
used our fear, and used our anger
Yeah.
to basically make a lot of money. I don't know what's going on here, but this story is not by far over. So make
Yeah.
sure you keep watching Gotham, Oakland. And I'm going to just sign out here. Peace, y'all. I
Peace.
love you.
Peace.
Thank you for watching. And we
Thank
love
you.
Oakland. We're going to fight for Oakland.
Absolutely. I'm going to continue to fight no matter what, because I love Oakland and we need to do that. I have family who lives in West Oakland. I grew up in West Oakland. And it's kind of like, it's not about whether you like coal or not coal. It's about what is the best financial decision the city should be making now, and what can we do to make sure that we don't harm. Nobody wants asthma. Nobody wants any of those things. But I tell you one thing too, what we need to do is strike a balance. While you're spending all this money on a losing coal lawsuit, you're letting fires and other environmental hazards go unchecked in West Oakland,
They
where
never
our
mention it.
children are there. So where do
They
you strike the
never
balance?
mention that. They never mention
Yes,
anything
where do
else
you strike the
affecting.
balance? And at some point you have to. But as long as these city council people are tied to No Coal and Oakland Group and are afraid of them, they're not going to stand up. And you need somebody who can say, that's all fine and well, I don't want coal either. But our courts have told us, state courts, federal courts have told us that we do not have a winning case. So
That's
go to the
true.
table. We're going
That's
to lose.
true.
How do we do it? What can we do? How can we work around the damage, the environmental concerns? Can we cover the coal? Can it go through covered something? What can
Oh,
we
they
do?
offered, they
How can
offered,
we
they
package
offered
it?
all of that. They offered all of that. But I will say this, because we already said our piece, so we got to wrap it up. If you're
Yes.
one of these elected officials and there are any further decisions to be made, and they require you to break that pledge you signed to No Coal in Oakland in order to do your job for the taxpayers who pay you, you
Yeah.
better make the right choice. So I swear, I don't swear to God. I don't need to. God got all our back. God love all of us. But I swear to myself, you're going to pay for it. You know me. Don't play no game. Stop playing these games with our money. All right,
It's,
y'all.
it's
Y'all have a good one.
outrageous. Okay. Bye-bye.
Yo, I swear it's only up from here. Yo, I swear it's only up from here. Yo, I swear it's only up from here. Yo, I swear it's only up from here.